We are live now, sir. We'll wait for a couple of minutes for the participants to pour in. We have a reasonable number of participants, so I'll start. Very good afternoon to all the panelists here and the attendees. I'm Mr.V.Inbavijayan. I'm part of the managing committee of Kfcri. Before we start into the webinar, I would like to comment a few things. First, an introduction on the institution itself. Kfcri functions in two wings majorly. One, it is an accreditation and a training body where we provide accreditations in the field of ADR, such as arbitration, mediation, conciliation, and even now as a tribunal secretary. Apart from this, Kfcri is an arbitral institution or an ADR institution in itself. We have our own rules in, again, all the fields of ADR, and we have some clauses which can be incorporated into different contracts. And any dispute arising out of such contract will be adjudicated by the institution as well. For this webinar, I would like to establish certain housekeeping rules. So Mr. Sharukumar will be the moderator of the session, and the speaker will have about 30 to 40 minutes of the session, and will be sharing the PPT as well. Once that is completed, there will be around 15 minutes for Q&A sessions. All the questions can be directed to the Q&A box, which you can find below. I request you to please refrain from texting from the chat box. Thank you everyone, and thank you panelists. Now I'd like to hand it over to Mr. Inbavijayan.
Thank you, Sweta. Good morning, good afternoon, and good evening to all the participants. Today, interestingly, Kfcri is very happy to organize this webinar, particularly in the very interesting hot topic, Tribunal Secretaries in International Arbitration. For that, we are fortunate to have the right person who has done the doctoral research on this topic itself to speak before you for another 45 to 50 minutes. Here we are having Dr. Jensen. He is right now the associate at Wilmer, Cutler, Pickering, Hale, and Dorr LLP, which is a very prominent international law firm which deals exclusively on international arbitration. And further, I like to share that Dr. has recently come out with a very interesting article which has been published in the Swiss Arbitration Association June 2020 in a caption, aligning arbitrator assistance with the parties' legitimate expectation, a proposal of a traffic-like scale of permissible tribunal secretary task. I think now Dr. Jensen is planning to make it as a traffic signal for all the tribunal secretary to start. With this few words, I like to hand over to colleague Sharuk so that we can officially commence the webinar. Thank you.
Thank you, Mr. Inbavijayan and Mr. Shwetan for the introduction. So, first of all, I would like to welcome the lead panelist, Dr. Jensen, for this webinar on Tribunal Secretaries and International Arbitration. So, this topic in itself is a dynamic one. The Tribunal Secretaries and International Arbitration has been a developing concept and has gained utmost significance in international arbitration over the past few years. Kfcri being one of the global institutions promoting the practice of tribunal secretary and being the only institution in India having a separate rules and terms of appointment for tribunal secretary, we wanted to have this webinar as an eye-opener for law students and graduates who are starting their practice in the ADR arena as tribunal secretaries. So although this, the practice of tribunal secretary has been used in arbitrations over a long period of time, there is still a few areas of tribunal secretary practice which is unclear and not defined and does not have a clear-cut definition. So I think Dr. Jensen would be the right person to approach in terms of practice as a tribunal secretary, the role of tribunal secretary, and how effective a tribunal secretary's mandate can assist the tribunal. So without much delay, I would now request the lead panelist, Dr. Ole Jensen, to start his presentation.
Well, thank you very much, first Mr.V.Inbavijayan, but also Sharuk and Sovetan for the very kind introduction, and of course also for inviting me to give this presentation on tribunal secretaries. I think, as has come across, this is a topic that has been close to my heart for a couple of years now. And as was also mentioned, we do want to have some time for a discussion. We do want to have some time for Q&A later on. So I thought what I would do now in the next 30 to 40 minutes is simply give you a short and hopefully brief introduction into the topic of secretaries to arbitral tribunals. And I'd like to address three separate points. First, it might make sense to quickly clarify what we're talking about when we're talking about tribunal secretaries. I'm going to go into the who gets appointed as secretary, what do they do once they are appointed, and finally, why do we have secretaries in the first place? Then it is quite interesting to note that in the past, let's say 5 years, there's been quite an increase in regulation on tribunal secretaries. Both by arbitral institutions and within case law. So there were at least 3 major cases on tribunal secretaries in key arbitration jurisdictions within the past 5 years. And I'm going to touch upon those as well. And then finally, since you know, this is also supposed to be something for younger practitioners to benefit from, I'm going to pick up 3 topics or 3 tasks that secretaries often carry out, and just give my, you know, my experience on how these tasks could be carried out and what it could be that secretaries do. Starting with that first point, and I'd like to take it from the back and first address why do we have tribunal secretaries. In my opinion, there can only be one serious answer to that question. And that answer is the only purpose of secretaries is to increase the efficiency and the quality of the arbitral process, and thereby to increase the overall attractiveness of international arbitration as a dispute resolution process. And I'm going to go into that in a minute. First, I'd like to briefly point out what the main things are that a tribunal is tasked with to do, and that are part of the tribunal's mandate. And that is the administration of the case, which is particularly important where an arbitral institution is not involved. So in ad hoc arbitration, there's quite a lot of practical, organizational, and clerical work to be done behind the scenes, which ranges from, you know, keeping the case file in order to things like booking hearing rooms and communicating with the parties. Closely related, but more procedurally relevant, is the conduct of the proceedings. How do we get from the initiation of the arbitration, from the formation of the tribunal, to an actual resolution of the dispute, usually by rendering an arbitral award? And, you know, within that course of navigating the proceedings, of going through the written phase to the oral hearing and then rendering the award, there's a plethora of procedural decisions to be made. Decisions on document production, decisions on whether proceedings should be consolidated, party could be joined, and so on. And then finally, of course, the main reason for the arbitral tribunal to be appointed, its raison d'etre, if you will, is the resolution of the dispute. And in all of these separate steps, tribunal secretaries can be involved to differing degrees in order to allow the tribunal to focus on its main task, the resolution of the dispute. And if the tribunal is able to do that, to focus on actually, you know, deliberating and making the decision, the idea or the hope is that the proceedings can move along more quickly, and that the quality also increases because those individuals who are tasked to do certain things can focus on those things. And something I'd also like to mention, just because of the setting we have here as well, is nothing that relates so much to the individual proceedings, but is a more systemic idea. And that is what I would call the apprenticeship function of the secretary position. In International arbitration, in the community, we have a big discussion right now about more diversity in tribunals. And I mean diversity in the broadest sense possible. So not only to have more regional diversity on tribunals, to have more gender diversity, but also to have more age diversity where it is appropriate. And the big problem about getting appointed as an arbitrator is, of course, that parties opt for individuals who have lots of experience in international arbitrations, who have a good track record of finishing arbitration successfully and rendering quality awards that won't be set aside. And to be able to break into that, club, as some have called it, of arbitrators, you need to gain first experience as an arbitrator. But how do you do that if you never get appointed in the first place? So it's a bit of a catch-22. You won't be an arbitrator without experience, and you cannot gain experience without being an arbitrator. And that is where the secretary function can be helpful. Without doing any of the resolving the dispute, secretaries are able to see an entire arbitration from beginning to end from the viewpoint of the arbitral tribunal. And that is immensely educational and immensely helpful if you plan on moving on further in the future. So that is an important aspect of the secretary position. And another important aspect is actually for counsel. So if the goal is to be more on the counsel side in international arbitrations, it can also be very, very helpful and educational to move perspectives and to move from the counsel table where you argue the case to the tribunal, try to persuade the tribunal to see it in your client's way, to actually sitting in the neutral spot right next to a tribunal and see how certain arguments or certain conduct by counsel resonates with the tribunal, and that way hopefully increase the efficiency of your advocacy as a counsel. So moving back to the three-pronged idea of the arbitrator's mandate, as I said, secretaries can be involved in all three of these main tasks that exist. And to illustrate that, I actually took a look at Kfcri's secretary rules, which is a quite novel thing to have, I would say. There are many institutions these days, and I'll tell you which these are in a minute, that have in some ways regulated tribunal secretaries. Sometimes it's one article in the institution's arbitration rules. Sometimes it's guidance notes, as is the case for the ICC and the LCAA, where the institution regulates or tells arbitrators how the institution expects tribunal secretaries to be employed. But what the Kfcri has done is draft actual rules, and that are a bit more detailed, I would say, than most institutions, and also had a specific list of tasks that can be carried out. And that is quite helpful for the purposes of our discussion. Because if you look to the left side, you can see these clerical tasks that I've talked about. The first part of the mandate that is mainly about the administration of the case. So tasks that would be carried out by secretaries relate to the communication on behalf of the arbitral tribunal with the parties. For example, where the secretary would, on behalf of the tribunal, acknowledge receipt of correspondence, of submissions, and so on. Depending on how the arbitral tribunal likes to operate, maintaining the case file can be an important task for secretaries. And the same applies to organizing hearings and meetings where the parties are not in charge of doing that. Tribunal secretaries often take time during hearings, ensuring that both parties have the same amount of speaking time before the tribunal, and thus, at the end of the day, ensuring equal treatment between the parties. And something that is maybe more important than some practitioners want to realize is cybersecurity. And that also especially applies to practitioners who are not, part of a larger law firm that have set up cybersecurity anyway. But arbitrators practicing more independently might benefit from secretaries setting up cybersecurity and ensuring compliance with data protection regulation for them. And then moving on to the right side, you might say that this relates more to the procedural conduct and the resolution of the dispute. So tasks that secretaries often carry out in practice, to which degree they are legitimate might be a bit of a different question, but usual tasks are research with regard to case law, using the case file to draft certain pieces of memoranda for the tribunal to navigate the case file more easily. Also attending the tribunal's deliberations, taking notes for the tribunal, maybe even while deliberating, fleshing out first structures or first parts of the award on instruction of the tribunal, and then preparing all different kinds of drafts. What I'd like to mention here, briefly flag, which I thought was very interesting, is that the Kfcri also considers it a legitimate task of secretaries to facilitate settlement between the parties. And that is interesting to me because, at least from an international perspective, there's still a quite big discussion going on whether even arbitral tribunals should facilitate settlement between the parties. We are moving quite obviously with the Singapore Convention and other developments. We're moving to a space where there will in the future most likely be a stronger emphasis on mediation and other consensual dispute resolution methods. But still there are, especially in the common law world, you could say, there are quite strong voices suggesting that arbitral tribunals are tasked with, making a decision, rendering an award, and not so much with facilitating settlement. And with regard to tribunal secretaries, you might have the additional obstacle that it would very much depend on the background of the secretary, to which degree the individual is, able to take over their tasks. Facilitating settlement, I would say, requires quite a lot of experience in handling parties, in coming up with, useful suggestions. And I would be a bit careful in flagging that as something that secretaries regularly do. But there are certainly certain domestic settings where that is not unheard of. For example, in Switzerland, judicial assistants before state courts, so-called greffiers or Gerichtsschreiber, they regularly facilitate settlement between parties, or at least that is something that is within their mandate. And then moving on to the who, which might also be relevant for people listening. Typically, and I think even though there are no strict rules, there's not too much regulation on who can act as secretary. Typically, it would be a junior lawyer of the arbitrator's law firm, assuming that the arbitrator is a practicing lawyer. That is for the simple reason that arbitrators will choose individuals as secretaries in the vast amount of cases who they are familiar with, who they have worked before, and who they trust in, getting them quality results. In some settings, especially in investment arbitration, in ICSID and PCA arbitrations, secretaries are also recruited or appointed from the relevant secretariats, or in the case of the PCA, it's called the International Bureau. So those are staff members of the institution who will be appointed to the tribunal and assist the tribunal as secretary, thereby somehow ensuring that certain tasks of the tribunal are carried out uniformly in the institution's practice, and also acting as the prolonged arm of the institution, of the secretariat, if you will. Another thing that commonly happens where arbitrators are also professors is that the professor takes a research assistant, maybe a PhD student, to assist as a secretary. And the same applies for judges who might just use their judicial assistants that they have in everyday life when they handle court cases. That is, for example, something that we still see quite a bit in Sweden, sitting judges who appoint their judicial assistants as tribunal secretary. And then we have, in rare cases, we have quite an interesting development, or you can observe quite interesting appointments of secretaries. In one recent case before the Svea Court of Appeal in Stockholm, the Arbitral Tribunal appointed a professor at Lund University. So someone with lots and lots of experience as a law professor, who was appointed as secretary of the tribunal. And that actually raised a setting aside proceeding by one of the parties, arguing that the tribunal had entrusted too much power to that professor secretary. But before the Svea Court of Appeal decided the case was settled. So we will not, learn anything more particular about that case. In other cases, individuals are appointed secretary in large arbitrations who also already got their first appointment as arbitrators, so there can be an overlap of individuals starting out as an arbitrator and ending their secretary career, if you want to put it that. And also what we've seen sometimes is that partners at law firms get appointed as secretaries, especially, and that is true for the UCOS case, which I'm going to go into in a minute, where the proceedings take a long time, and then who might have been an associate at the beginning of the proceedings might actually move on to be a partner of that law firm towards the end of the proceedings. But these are exceptions, and the rule is that you would find secretaries who are anywhere between students, PhD students, to maybe you could say about 5 years of post-qualification experience. Just to illustrate this point, because I think it's good to see some faces as well. On the left, you have the UCOS Arbitral Tribunal, and the tribunal in UCOS called this a mammoth arbitration, and I think that is correct in every sense of the word. UCOS is today the largest arbitral award that is known, in excess of $50 billion US. I'm not going to go into the details of the dispute. It was an investment arbitration. The UCOS shareholders initiated arbitration against the Russian Federation under the Energy Charter Treaty for an expropriation. And the proceedings started in 2005. The award was rendered in 2014, so close to 10 years is the amount that the proceedings took. And on the left, you see a picture of the tribunal, the 3 gentlemen in the middle. And then to the right, you actually see 2 tribunal secretaries appointed by the PCA. That also sometimes happens in these larger cases, that you don't have 1 but 2 secretaries. And then to the left, you see a tribunal assistant. And in principle, that is not something too different from a tribunal secretary. It's just a different terminology in PCA proceedings and exit proceedings, because you have these institutional secretaries. And then when the arbitrators, in addition, appoint someone from their law firm to act as, more personal assistant, that individual is called the tribunal assistant. And you see that gentleman on the left of the group. And then to the right, just to illustrate that sometimes rather senior lawyers can also be appointed as secretary. You see a barrister practicing in London, and she had been practicing before the ICJ already, while she was also concurrently appointed secretary in some, or tribunal assistant in some investment arbitration cases, who ended up marrying George Clooney, as most of you will know. And then finally, when we talk about who are tribunal secretary, I think it makes sense to talk about how do they get appointed? How do you end up being a tribunal secretary? And in principle, 3 different types of appointment mechanisms, you might call them, can be distinguished. Most usually today, I would say you have general consent, where the arbitral tribunal approaches the parties at the beginning of the proceedings, provides them with a CV and confidentiality undertaking, impartiality and independence statement of an individual who they propose to appoint as tribunal secretary. Specific tasks that secretary will carry out are usually not discussed, and then you have general consent. Something that we see more and more, and which I think is the right approach of doing it, is discussing with the parties, or at least disclosing to the parties, the types of tasks the individual will carry out. And if the parties then consent, that is what I would call qualified consent. And then at the other end of the spectrum, which also we still see quite a lot, are entirely undisclosed secretaries. So those would be individuals who assist tribunals completely in the shadows, if you want to put it poetically, and who are not, might not even be disclosed to the co-arbitrators, but certainly not to the parties. That can raise certain difficulties with regard to confidentiality, with regard to impartiality and independence, and not least, depending on which tasks those individuals carry out, with regard to the personal nature of the arbitrator's mandate. So the better practice is to get some form of consent from the parties. And that actually takes me to the second part of the presentation, because the fact that that is the better practice also derives from institutional regulation that we have seen quite a lot in recent years. The ICC actually has regulated tribunal secretaries since the late 1980s. So, for more than 40 years, or close to 40 years, the ICC has in some way or another regulated tribunal secretaries. But it was more or less the only institution doing that, maybe other than the Swiss Chambers Arbitration Institution, who did that as well. Other institutions have started regulating secretaries more recently, which also had to do with quite a lot of case law coming out and on tribunal secretaries. For example, the SCC in 2017 included one article in its actual institutional rules rather than in guidance notes or soft law instruments that the institution publishes. And as you can see here, in 6 subsections, quite a bit on the secretary is regulated, ranging from the appointment, where the institution says the approval of the parties should be obtained, to, in subsection 2, the fact that the parties should also be at least consulted regarding the tasks that the secretary will carry out. And something that is also, of course, a concern for parties is who will actually pay for the secretary. And the remuneration in the vast amount of cases will be carried by the tribunal, because the idea the institutions have is that since in ad valorem cases, so where the institution remunerates arbitrators or the parties remunerate arbitrators based on the amount in dispute, they will get a lump sum. And if they get a lump sum for conducting the entire arbitration, the idea is that it is only fair that the arbitrators also pay for the secretary. In other cases, for example, before the LCIA, arbitrators are remunerated at an hourly charge. And in that case, to reduce the hourly charge of the arbitrators with a lower rate of the secretary, it can make sense, or it can be more economical for the parties to actually carry the fees of the secretary. But that is something you will usually find in the institutional rules. And then, as I said, there has been a few cases dealing exclusively with the secretary, and or at least in part dealing with secretaries. And these are in Switzerland, in England and Wales, and in the Netherlands, having come out between 2015 and actually this year, earlier this year. And I'd briefly like to go through these cases and show what these courts have said in terms of how secretaries get appointed, what tasks they usually carry out, and also what the limits are that should be entrusted to the secretary. With regard to the Swiss case, you might say that is a more unusual case. In that case, it was a sole arbitrator who was not a lawyer, but an architect, a construction case, and the architect had been appointed to decide the case, but felt like he required assistance in maneuvering the procedural intricacies of international arbitration. And for that purpose, the architect arbitrator not only appointed a secretary, a tribunal secretary in the usual sense, but also a legal consultant is what the judgment calls it. A legal consultant who apparently took part in the oral hearing, asked questions to witnesses and the parties, and almost acted as, in every sense of the word, true assistant to the sole arbitrator. The English case was an LCAA case, a rather large one. And in that case, the tribunal had actually obtained the parties' consent to the appointment of the secretary without further disclosing what the task would be. And then in the course of the proceedings, one of the parties applied for document production and requested certain documents. And one of those applications was forwarded by the president of the tribunal to the secretary, saying something like, very succinctly, "Dear secretary, what is your reaction to this latest application from the claimant?" But rather than forwarding it actually to the secretary, the president replied all and sent that message back to the parties. So the parties were aware how, in that specific case, the president and what the president communicated with the secretary. And based on that communication, the parties challenged the entire tribunal. They challenged the president for allegedly over-delegating to the secretary, and they challenged the co-arbitrators for not policing the presiding arbitrator in not delegating too much. And then finally, the UCOS case, that is a true saga. As I said, the case started in 2004, 2005, and now it's 2020, and we still get court decisions on that case. And in that case, the decision by the Hague Court of Appeal also involved some paragraphs on the secretary. Briefly moving on to what the court said about the basis for the appointment of a secretary. in the English case, as I already mentioned, the parties had agreed that the chairman appoint a secretary, but there had been no agreement on the limits of the secretary's role. And in the Swiss case, it's not clear whether the parties actually even were asked or whether they consented to the appointment. From the case, it more seems like the architect arbitrator presented a fait accompli to the parties and just presented those two individuals helping him. And the court then said, there's nothing that prevents the architect arbitrator from hiring counsel and a secretary to assist him in the conduct of the proceedings. So you could say rather liberal approach. The same is true for the UCOS case. In that case, from what we know from the public documents, in the original case management conference back in October 2005, the chairman had brought to the attention of the parties that he had asked one of his colleagues to assist him in the arbitration. And not much more was discussed other than that this colleague would somehow assist in the arbitration and that the parties could turn to that colleague if they had any questions and couldn't reach the tribunal. The Hague Court of Appeal considered that approach that works in practice and said that where the parties do not pose any limits by agreement on the involvement of the assistant or secretary, it is left to the discretion of the tribunal how the tribunal will make use of the secretary. And I believe there's some force to that argument because it is, of course, a general principle in international arbitration, both in national legislation and in institutional rules, that where the parties do not make an agreement on anything that regards the procedure of the arbitration, the power to make these determinations moves to the arbitral tribunal. And you could say that also applies to the organization of the proceedings and to obtaining help from secretaries. The Swiss Federal Tribunal compared the role of the secretary to that of a state court clerk and basically mentioned the tasks that I already mentioned that are in the Kfcri rules, which is organizing briefs, preparing hearings, keeping minutes, and preparing statements of costs and whatever administrative issues might have to be done. Similarly, the English court said secretaries analyze submissions and draft procedural orders. And at least with regard to questions of procedure, the court also noted that it would not be improper delegation of duties if the chairman, solicited views regarding the procedure from the secretary, as apparently had happened in that case. And then to the limits, and I think that is interesting also to consider. What are the limits of secretary involvement? The Swiss court considered that any function of a judicial nature may not be delegated to a tribunal secretary. And then, of course, the big question is, what are functions of judicial nature? And you can write longer books about that question, discussing what are the core functions of an arbitral tribunal. But at least you know that something like making the actual decision or participating in the actual decision making would certainly be such a judicial function that cannot be delegated. In more words, the English High Court said the same. The court said it is at least a best practice to avoid involving the tribunal secretary in anything which could be characterized as expressing a view on the substance as opposed to a view on the procedure. That should be avoided. And the Hague Court of Appeal even went so far as acknowledging that because there were, which is also interesting in itself, there were linguistic expert reports opining that the secretary or the assistant in that case had written large parts of the award with certain amount of certainty. And the court said, even assuming that the assistant took part in drafting the award, that is not reason to set aside the award because the violation of the arbitrator's mandate, if there was one, must be serious. So yeah, maybe as a takeaway from these cases, we do have some guidance now by national courts, which is very helpful. You could say that national courts have been rather liberal in terms of what tasks they afford to tribunal secretaries. And certainly they did not think that drafting at least parts of the award would be a violation of the mandate. Then in the last 5 minutes, hopefully, let's briefly touch upon more specifically what secretaries do and how certain tasks can be carried out. And I'd like to focus on 3 usual tasks, I would say, which is keeping the case file together and working on the case file for the tribunal, attending and organizing oral hearings and deliberations for the tribunal, and drafting different documents. Talking about the case file today, we still see physical case files, even though, as a matter of the general technological evolution, that is disappearing more and more. Where we do have physical case files, it would be for the secretary to keep them together, to arrange new submissions by the parties in them, maybe to procure photocopies where the tribunal requires more copies of the case file than the parties provide, and so on. More relevantly today, digital case files. To the right, you can see, some structure you could use to file certain documents you get from the parties within the course of the arbitration, ranging from their actual submissions to written witness statements, expert reports, and legal and factual exhibits. And it can be quite helpful to file them right away. It is essential, I would say, to keep enough backup copies of those documents, because in many of the larger cases, tribunals will share exhibits and other parts of the file on FTP file transfer links, and then the secretary would download them and maybe copy them on a USB stick, or at least somewhere to have a safe backup copy, because these FTP links tend to expire, and then it's not ideal to have to ask the parties to provide these documents again. So that is something that the secretary would be in charge of. Also organizing, that's what some tribunals prefer, cloud storage, and to make sure that the cybersecurity for cloud storage is in place, and then you could use that file structure for the entire tribunal to access the case file. And something I would say that is a very important task of the secretary, and that lots of tribunals appreciate as assistance, is facilitating the tribunal's navigation of the case file. It's not unusual, in mid-sized commercial arbitrations, that at the end of the proceedings, before the oral hearing, but also before rendering the award, the entire case file, the entire submissions are hundreds to 1,000 pages long. And then, of course, it's one of the key tasks of the tribunal to digest all those submissions, to read them carefully. But when revisiting the submissions, it can be very helpful to have certain documents drafted that facilitates the understanding of the case. And that is, for example, true for chronologies of events. That is something that that I've heard several times is helpful to arbitrators. And that is what you see to the right here. That is, the task would be to draft a timeline, and then go through the entire written submissions and fill in what happened at what point in the dispute. And that allows the tribunals to rather quickly familiarize itself with how the dispute has developed, how it has evolved, what happened when, and also sometimes from the submissions, it's not immediately obvious that a certain phone call might have happened before an email was sent, or the other way around, and that timeline might clarify these things. The same applies to summaries of the parties' positions, where more succinctly than in these submissions, the secretary would maybe use a table, and on the left side of the table have all the claimants' arguments sorted by issue, on the right side the respondents' replies to those arguments, and then might be more easy for the tribunal to later on remember what the parties had argued. When it comes to hearings and deliberations, and I don't want to spend too much time on that, usually the parties in the arbitrations, in the large arbitrations, usually the parties would organize the hearings and meeting rooms and so on. And where that is not the case, then it would be the secretary who can be in charge of that. And then there are different things to keep in mind. For example, that if there are interpreters, they need separate cabins. The tribunal and the parties will need breakout rooms where they can discuss it privately, and so on. But in the vast amount of cases, that is done by the parties. During the hearing, something that the secretary will always do is keep time. And that is done in addition to the parties also keeping time. Usually hearings have quite a meticulous agenda of what happens when and what time is allocated to each party. And then it's important to stay on top of that. And one way of doing it is keeping an Excel sheet, and for every day noting down for how long each side has spoken or examined witnesses and so on. And of course, everybody's talking about that at the moment, remote hearings, maybe even entire remote arbitrations, where in the course of an arbitration, the proceedings are initiated by email. Any case management conferences and even entire oral hearings are conducted by video conference, as we're doing right now. And of course, that involves rather novel, for many arbitrators, novel technical issues. And I would say a tribunal secretary is ideally poised of helping with that. For example, being the meeting host, admitting participants to the platform, locking the platform once everybody's there, muting participants that have forgotten to mute the microphones, and so on. If the chairman who has to moderate, or the chairperson who has to moderate the entire proceedings would have to do that in addition to moderating, that can be too much, and that is something the secretary can very well do. And then finally, drafting assistants. Maybe the most controversial task of tribunal secretaries, and where the opinions diverge the most. I don't want to go, into the nitty-gritty details and discuss the propriety of doing drafting for the tribunal. But I'd like to flag that something that is often done, and that is, I would say, rather uncontroversial, is prepare first drafts of the terms of reference of the procedural order number 1. And that is for the simple fact that in many cases, these are being drafted based on templates. And of course, it's important in international arbitration as a flexible dispute mechanism not to use boilerplate language and apply the same terms of reference, apply the same PO1 to all cases, but certain language just will stay the same. And then it's a usual task for secretaries to take maybe a prior PO1 or a template for a PO1 and just implement the details of the dispute and the parties' names, the counsel's addresses, and so on. And then send it on to the tribunal for the tribunal to refine and maybe adopt the PO1 to the specificities of the case. And then finally, as the last slide of my presentation, a few words regarding drafting of the arbitral award, or at least secretary assistance with regard to the arbitral award. I noted in the beginning that one of the important efficiency increasing functions of secretaries is to facilitate and speed up the rendering of the award once the entire burden of arguing the case moves from the parties over to the tribunal. And the tribunal must then develop a coherent and convincing decision. And in that tasks, there are rather uncontroversial things the secretary can do, and that is the first box here. For example, the tribunal might not want to hold itself up with formatting the document that the tribunal that the award is drafted in, cross-referencing, footnote fixing, applying styles, citation styles to the footnotes that are uniform throughout the award. All these, dotting all the I's and crossing all the T's. That is something that secretaries often do, and that is completely legitimate for them to do, I would say. Moving on the continuum of secretary involvement would be a scrutiny function. So that is also something that quite a few arbitral institutions do to differing degrees, most famously the ICC, where, for example, the ICC court will go through an award and see, just as an example, the parties might have agreed on a cap of liability of, say, 500,000. The tribunal awards 10 million, but doesn't explain why the cap wouldn't apply. And then the court would come back and say, dear tribunal, do you feel you would have to reconsider that decision? And then the tribunal can take that into account. And something similar can be done by the secretary, just going through the award, reading everything, and checking for plausibility. And then moving on to actual drafting exercises, again, as I said, it's rather controversial still. Most would agree that drafting formal and uncontroversial parts of the award is fine. For example, the cover page, preliminary matters, to the extent that the procedural history is uncontroversial, that could be done potentially by the secretary. And then when we move to drafting substantive portions of the award, the actual reasoning, that's arguably the place where the tribunal has to be most careful not to delegate actual decision making. And one way of making sure that doesn't happen is strict instruction of the secretary. So setting out in detail what the tribunal wants to decide. Close supervision during the drafting process. So if the secretary comes across any problems with the intended decision, the arbitrator would have an open ear for the secretary to approach and discuss that individual point. And then maybe most importantly, close verification by the tribunal, making sure that what has been drafted in fact resembles the decision the tribunal wants to make. And that would be it from me. Just under 40 minutes, and looking forward to discussion. A few quick notes, just shameless plugs of, and Mr.V.Inbavijayan has already mentioned it, of a few publications, further reading if you're interested in the topic. The article that just came out, the traffic light scale that was mentioned, basically explains one of the ideas I have developed in the book to the right. And that is something I did not go into today, but of course I'm happy to discuss that as well. And there was rather good news recently. The book to the right, which is published by Oxford University Press, is now also available on Kluwer Arbitration, to which people tend to have more wider access. So thank you very much.
Thank you so much, sir. So I guess you have given a very great presentation within the short time, starting from who is a tribunal secretary, what is his role, and what are the recent developments with regard to case laws, and finally with the practical tips to act as a tribunal secretary. So I think that's a very great presentation within a short span of time. So before moving on to the Q&A session with the attendees, I have a few questions to be posted regarding tribunal secretaries. So my first question is it mandatory that a tribunal secretary should be available at the same locality as the arbitral tribunal? So in international arbitration, there is a practice that arbitrators travel from countries to countries for their hearings, and it is not necessary that all the members of the tribunal are from the same country. So can that practice be incorporated with regard to tribunal secretaries also? Is it possible for a tribunal secretary to assist a tribunal or by staying in a different country or a locality?
The short answer is yes, I would say. For the simple reason that lots of the tasks that a secretary carries out, for example, going through the case file and drafting the chronology that I mentioned, do not require, personal interaction with the arbitral tribunal. Having said that, again, the way most people become tribunal secretaries is because they closely work together with the arbitrator, with the presiding arbitrator in the vast amount of cases. And then it is almost a given. Let's say if you work in the same law firm, that you regularly are in the same location and meet in the same place. So I would say just looking at what happens in practice, that is usually how it works. At least the presiding arbitrator and the secretary are in the same physical location, but that is certainly not a must. And there can be entire arbitrations where maybe except for an in-person hearing, the tribunal secretary and the actual arbitrators never meet. In theory, that's well imaginable.
So another question is that the general notion is that there is no particular qualification or requirement for a tribunal secretary. But a few jurisdictions and rules that I have come across have mandated a criterion for tribunal secretaries. To be specific, the Court of Arbitration for Sports, their rules mandate that a person with qualification in sports law can only be appointed as a tribunal secretary. So another view to this is that if a person with masters or with special experience, specialized knowledge in a particular subject is appointed as a tribunal secretary, his role gets transferred to that of a expert opinion. So how do you view this? What could be the perfect designation a tribunal secretary can possess? Whether he should be specialized in a particular subject, or he can be a neutral third-party support to the tribunal?
Yeah. Excellent question. I think it's interesting to the degree where jurisdictions or institutions actually regulate that, regulate minimum qualifications, because we hardly have those for arbitrators as well, right? An arbitrator does not have to be a lawyer, for example. An arbitrator does not have to undergo any specific training. It's more regulated by practice that only very experienced individuals in international arbitrations get those appointments, but there is no strict regulation on that. And in principle, I would say there's no reason to have strict regulation on the secretary, because since the secretary immediately works with the tribunal, it is for the tribunal to decide who they are comfortable with working with. And if that individual, has certain qualifications that are helpful for the job, that is something that the tribunal will take into account. Now, with regard to the CAS that you mentioned with sports arbitrations, it of course might make sense that if there are certain intricacies in that field, that the secretary has familiarity with that. But in fact, I've come across parties or heard anecdotal, evidence that some parties are more appeased if the secretary actually does not have those qualifications. So as an example, there might be a case where the applicable law is Austrian law, say, and then the arbitrator has two individuals who she usually works with, a Romanian and an Austrian qualified lawyer. And then the arbitrator might choose a Romanian qualified lawyer, or the parties, voice a preference for someone who is not qualified in Austrian law, just because there's less of a, chance or danger that the secretary will carry out tasks more closely related to the decision making than if that individual is not qualified in the applicable law. I think that also relates to that question, that it can be the other way around. It can actually be detrimental when you are, an expert in the substance of the dispute.
So I think that answers my question. So thank you so much, sir. So we have quite a few number of questions from the attendees. I think we'll try to answer as much as possible within the given time. So Colonel C. Harsha has put a question. Can one of the duties of the secretary be to provide legal opinion or advice to the tribunal?
I would say that providing a legal opinion is one of those tasks that should be handled with care. For the simple reason that applying the law to the facts, and it would be my understanding that that is what a legal opinion does, or at least clarifying what the law is an inherently personal duty of the arbitral tribunal. Now, I would argue that virtually any task can be carried out by a tribunal secretary so long as the parties consent to that task. I do not see any, inherent limit to what tasks can be carried out if the parties want the secretary to carry out these tasks. One example is a investor-state arbitration in which there was a dispute about document production. And one party had argued that certain privilege rules applied to certain documents, that they should not be disclosed. And the other party said, well, we cannot look at those documents. There's no way of ascertaining that they are in fact privileged. And we need someone to make that decision. And if the tribunal were to look at those documents and then determine, yes, they are privileged and they cannot be produced, then the tribunal might be biased because they have inevitably seen those documents. And in state court settings in the US, for example, you would appoint document production masters for that task. Third parties, individuals not connected to the tribunal or the court who make that determination. And in that specific investor-state arbitration, the parties agreed that the tribunal secretary would make that determination. So that is a limited actual, substantive decision that the secretary carried out. And since the parties had agreed, that was perfectly all right. I would be more hesitant with providing legal opinions.
So I think we have another question regarding what is your opinion on the role of tribunal secretaries in dispute resolutions other than arbitration? So can tribunal secretaries be appointed in other ADR mechanisms?
I know that there are assistants to mediators, which you might call a mediator secretary or mediator assistant. I have not thought deeply about what that might implicate. With regard to mediation, which is inherently confidential, of course, that is an issue that might come up. So it might be more difficult for a mediator to have someone behind the scenes assisting her or him, rather than that individual being disclosed to the parties. And then, maybe even taking part in the mediation session, maybe drawing up certain schemes on a sideboard and so on. I think there's certainly scope. I mean, the whole idea of tribunal secretaries is, of course, not unique to international arbitration. You have judicial assistants, and in all walks of life, you have assistants to important decision makers. You see it in politics. You have politician aides and lots of them in big companies. There's a huge structure of assistants to the CEOs and so on. So that's really not unique to international arbitration, and of course not to any dispute resolution mechanism.
So I think we'll have one last question before we conclude. The question from Mr. Badrinath Srinivasan: what's the potential in India for tribunal secretaries as a profession for young lawyers?
Yeah. So I would say India is rather well poised for young lawyers acting as tribunal secretaries, for the simple fact that institutional arbitration is not as big as ad hoc arbitration in India. And as I mentioned, one of the key tasks of secretaries that can be carried out by younger lawyers is facilitating the administration of the case. And then a key qualification, if you will, you would have to have as a secretary is being diligent and being humble. Diligent because it is essential to be very keen on getting all the details right. As I said, crossing all the T's, dotting all the I's. It's the main task of the secretary to make sure everything that comes from the tribunal is up to standard. And you have to be humble because you have to understand that the secretary will always only be an assistant to the tribunal. It's an aide in the background. It's an important individual if he or she is employed well, but it's not the key player. So it's important to be humble. In India, in terms of, and I guess that's another question that comes up quite frequently, how do I actually become a tribunal secretary? What's the avenue I could take? And I would say it's infinitely more difficult than pursuing law firm careers, where you have law firms advertising roles and many to choose from. With regard to being a tribunal secretary, because one of the key qualification criteria is knowing the arbitrator and being familiar with the arbitrator. It's one of the usual ways of doing it is getting to know an arbitrator, be it as a PhD student for an arbitrator who is a professor, or any kinds of student really, student assistant, or by joining a law firm with partners who act as arbitrators. There's a third avenue, I would say, and that is coming up more recently. And of course, the Kfcri is a example in point that you can qualify as a tribunal secretary. There are other institutions as well, the ICC, the HKIC, the London Court of International Arbitrations. They have tribunal secretary trainings. And then, of course, you can at least show something and show that you have a certain experience in a topic. And some of these institutions also have tribunal secretary rosters. So where you can put your name onto a roster of an institution and then hope to be chosen. But again, I would think that the chances are limited, and you would have to wait for a long time till a totally unknown tribunal comes along and thinks, I want that name, I'm choosing that individual.
I think you have also given an insight on how we can start our practice as a tribunal secretary and how to start a career. So I think with that, we would conclude this session of webinar on tribunal secretaries. So my sincere thanks to Dr. Ole Jensen for giving us this session in his busy schedule, and having said that he has almost explained all the nuances of tribunal secretary within the short time, including the Q&A session. Thank you, sir. So with that, I would now request Mr.V.Inbavijayan to give a few words.
Thank you, Dr. Ole Jensen. Really, your presentation is an eye-opener for young practitioners as well as law students. The words, what you have mentioned about diligent as well as humble, surely that is going to be the thumb rule behind the person who is interested to take up as a tribunal secretary. One another thing I also personally wanted to just supplement what your presentation about tribunal secretary is that the tribunal secretary should have the aspirations to arbitrate. That is very important. When they have the aspiration to arbitrate, and with this qualities and qualifications what you have suggested, like diligent, humble, as well as the knowledge what they are possessing, they can really be a good tribunal secretary. And with that few words, I wholeheartedly thank on behalf of Kfcri for sparing your valuable time. I think it's a morning, mid of the week in London, spending a reasonable time sharing about tribunal secretary from the words what you have prepared, the doctoral thesis, would be really helpful for practitioners as well as our members. Thank you, Dr. Oligens. I'll now request Svetan to conclude.
Again, thank you, everyone, and special thanks to Dr. Jensen for joining us and for this very special topic again. And all three of us mentioned this topic as being very special is because me, as well as most of my colleagues at Kfcri, have started our careers, even though we being law students, as tribunal secretaries. And we did learn quite a deal from your thesis and the other research material we could find online. So it has been quite helpful, and this seminar has been, again, really interesting and helpful. Thank you so much for joining us. A bit of logistics before we end. So we have recorded this session as well. So people who have missed out, or if you want to share this webinar to anyone else, we'll be uploading this in our YouTube channel. We'll share the link via email to you. And there are quite a lot of interesting but yet unanswered questions in the Q&A box. We apologize for not answering all of them because of the brevity of time. So you can again email the unanswered questions to kfcri.adr@gmail.com, and we will try to get them answered as early as possible. The details with regard to any future webinars of Kfcri will be again reached to via email. Thank you so much for all the attendees who joined us, and thank you, Dr. Jensen and Inbavijayan and Sharukumar for joining us. Thank you.
Thank you, Dr.
Thank you very much. It was a great pleasure, and thank you everybody who joined, and especially, of course, the entire Kfcri team for inviting me. It was lots of fun.
Thank you.